Good afternoon, and welcome to the second day of our virtual conference for the Eastern District of California. I'm Brandy Gustafson, the co-chair for this year's conference. Just like the first day of the conference, you may submit any questions that you have through chat, which will be answered, time permitting, at the end of the presentation. Now I'd like to introduce and take a moment to thank Robin Lipsky, the Executive Director of the 9th Judicial Circuit Historical Society, who without her and the 9th Judicial Circuit Historical Society's invaluable support, this session would not be possible. So please take a moment and welcome Robin.
Thank you so much, Brandy, and for welcoming us here. On behalf of the Eastern District of California and the NJCHS, it is my honor and privilege to introduce our speakers today. I could easily fill a large portion of the program speaking about them and their extensive accomplishments and accolades, but I know you came here to hear what they have to say, and so I'll make these introductions briefer than what each of these incredible women merits. I'll introduce our speakers in the order you'll hear from them, and then I will turn the program over to Judge McKeown. In a testament to the perspicacity of Girl Scouts, they honored Judge McKeown with their Cool Women Award. This honor is reserved for women whose demonstrated courage, confidence, and character make them the consummate role models for girls. Judge McKeown indeed embodies all of these characteristics because in addition to sitting on the 9th Circuit Court of Appeals, she also lectures and teaches extensively on intellectual property, international law, human rights law, litigation, ethics, judicial administration, and constitutional law in the US, and when people could go there, in Latin America, Asia, the Middle East, and Europe. Judge McKeown is immediate past president of the Federal Judges Association and is currently chair of the ABA Rule of Law Initiative Board. She serves on the Council of American Law Institute, the Executive Council for the American Society of International Law, the Managerial Board of the International Association of Women Judges, and the editorial board of the Litigation Journal. In addition to the Girl Scouts Cool Women Award, Judge McKeown has received numerous other prestigious awards, including the ABA's Margaret Brent Award, ABA's Margaret Brent Women of Achievement Award, and the ABA's John Marshall Award, the Georgetown University John Carroll Award, the Georgetown University Law Center Dreenan Award for Public Service, the California Bar Intellectual Property Vanguard Award, the University of Wyoming A&S Outstanding Alumna Award, the Outstanding Mentor Award from Big Sisters, and the Federal Bar Association Community Service Award. In her spare time, and I'm guessing that's between 2 and 4 a.m., Judge McKeown is also completing a book on Justice William O. Douglas and his environmental legacy, which will be published in 2021. Next, we will hear from the 9th Circuit's Judge Morgan Christen. In addition to her direct judicial duties, Judge Christen also serves on the 9th Circuit's Judicial Council, the 9th Circuit's Executive Committee, the Circuit Conference Executive Committee, the Courts and Communities Committee, the Pacific Islands Committee, and she chairs the Cameras in the Courtroom Committee. Judge Christen has chaired the Rhodes Scholarship Selection Committee for District 14 from 2017 to the present. Prior to her appointment as a 9th Circuit judge, Judge Christen was appointed to the Alaska Superior Court in 2001 and served as presiding judge of the 3rd Judicial District from 2005 to 2009. She also served as a justice on the Alaska Supreme Court. In October 2019, Judge Christen began a 3-year term on the Judicial Conference Committee on Federal State Jurisdiction. Judge Christen was awarded the Light of Hope Award for work on behalf of Alaska's children, and she and her husband, Jim Torgerson, were named Philanthropists of the Year in 2004. Judge Christen is a past recipient of the Alaska Supreme Court's Community Outreach Award, the Chamber of Commerce Athena Award, and was named YMCA Woman of Achievement. In addition to being a great intellect and a dedicated public servant and speaking extensively on enfranchisement and many other topics this year, as all of the above demonstrates, I can say from personal experience that unlike my unrealized pandemic aspirations, Judge Christen actually also somehow finds time to make an amazing homemade raspberry jam. We will also hear this afternoon from Professor Martha Jones. Professor Jones is Society of Black Alumni Presidential Professor and Professor of History at the Johns Hopkins University. She's a legal and cultural historian whose work examines how Black Americans have shaped the story of American democracy. Professor Jones is the author of Birthright Citizens, A History of Race and Rights in Antebellum America, which won the Organization of American Historians Liberty Legacy Award for Best Book in Civil Rights History. the American Historical Association Littleton Griswold Prize for Best Book in American Legal History, and the American Society for Legal History John Philip Reed Book Award for the Best Book in Anglo-American Legal History. Professor Jones is also author of All Bound Up Together, The Woman Question in African American Public Culture, 1830 to 1900, and was co-editor of Toward an Intellectual History of Black Women, together with many other important articles and essays. Her most recent book, published this year, is entitled Vanguard: How Black Women Broke Barriers, Won the Vote, and Fought for Rights for Us All. She is currently at work on a biography of U.S. Supreme Court Chief Justice Roger Brooke Taney. Professor Jones is recognized as a public historian, frequently writing for broader audiences and outlets, including the Washington Post, The Atlantic, USA Today, Public Books, and the Chronicle of Higher Education and Time. The curatorship of museum exhibitions, including Reframing the Color Line and Proclaiming Emancipation, in conjunction with the William L. Clements Library, and collaborations with the Smithsonian's National Portrait Gallery, the Charles Wright Museum of African American History, the American Experience, the Southern Poverty Law Center, PBS, Netflix, and out in France. Professor Jones holds a PhD in history from Columbia University and a JD from the CUNY School of Law. Prior to the start of her academic career, she was a public interest litigator in New York City, recognized for her work as a Charles H. Revson Fellow on the future of the city of New York at Columbia University. Professor Jones currently serves as a president of the Berkshire Conference of Women Historians and on the executive board of the Organization of American Historians. We are so thrilled to have each of these wonderful speakers here with us today, and I now turn the program over to Judge McKeown.
Good afternoon, and my thanks to the Eastern District of California for celebrating the 19th Amendment and the 100th anniversary. As you all know, when the Constitution was written, it was written by, for, and from the perspective of men. And it's interesting that Abigail Adams said at the time, 1776, she presciently advised, "Remember the ladies." And it's no surprise that Hamilton the musical includes these lyrics from the song, The Schuyler Sisters. "We hold these truths to be self-evident, that all men are created equal. And then when I meet Thomas Jefferson, I'm going to compel him to include women in the sequel." Well, the sequel took almost 150 years to come about until the amendment was ratified in 1920. 7 decades, 3 generations. And those who started had died by the time the amendment crossed the line, and many who took it across the line were not even born at the time. So instead of starting where it ended, let me start where it began, and that's in the West. And I think it should be called How Women Won the West rather than How the West Was Won, because women in the Western United States enjoyed the right to vote some 50 years before it became a national amendment. I'm a proud native of Wyoming, so I want to quickly share that story with you, because the Wyoming Territory was the very first in 1869 to give women the right to vote. Now, the high ideals of suffrage didn't exactly mix with Wyoming's ideas. In fact, there was a huge gender imbalance. There were so many men. The legislators thought, let's bring out some women and kind of try to equal things up. So it was an early version of every vote counts. Now, many Wyoming legislators thought it was only fair that women should have the right to vote, particularly white women, if already Black and Chinese people had the right to vote. So one newspaper claimed this racial animus was really the clincher argument of why women in Wyoming got the right to vote. It was also truly the Wild West, and legislators hoped that maybe bringing some women to the territory would up the moral quotient in the West. So regardless of these motivations, Wyoming's commitment to equality remained steadfast once it took hold, and it is now called the Equality State. It was the first state to grant women the right to vote when it entered the Union in 1890. And it has a long history of that. You'll see a photo here of Esther Hobart Morris. She was the very first female judicial officer in the United States. She was a justice of the peace in South Pass City. She doesn't look all that friendly here, but I have to tell you, she literally had to push the guy off the bench after she won the election to be justice of the peace. And she's now in the Congressional Statutory Hall. But Wyoming also has a long legacy of other firsts. They had, in this legacy, there was Wyoming's first woman governor, first town governed entirely by women. And when finally Wyoming entered statehood, and we'll look at the next slide here, maybe, when Wyoming entered statehood, Congress wanted to keep them out because they had given right to vote. And Wyoming said, no way, no right to vote for women, we don't come in. So I love this statue, which is at the University of Wyoming, called Breaking Through. And that's what Wyoming did for women's equality. So now I'll turn it over to Judge Christen to talk about what else was happening in the West.
Thank you very much for that kind invitation and for inviting me to speak at your conference. My task is to give an overview of the suffrage campaigns out West, and doing so in the time available is going to require that I speak pretty darn quickly. So I'll apologize in advance for having to talk fast. Broadly speaking, what I came away with, my big takeaways from the research I did, are first, of course, as Judge McKeown has explained, that progress actually moved in the suffrage movement from west to east, not the other way around, which is what I would have thought. Second, that the suffrage was very definitely a continuation of the battle over the 15th Amendment, including overt racial overtones. It wasn't just about gender. Third, that it's wrong to think of Jim Crow laws as historical relics from the Deep South. Unfortunately, Jim Crow laws were alive and well on the West Coast, including in my home state of Alaska, throughout this period that we're going to talk about. And fourth, that ratification of the 19th Amendment did not mean that all women could vote in America any more than the 15th Amendment allowed all African American men to vote. Poll taxes and literacy tests and barrier after barrier were erected in the years that followed. I'm going to start with these photos of the Ninth Circuit's headquarters in San Francisco. The building was opened in 1905, a very different time when most of the states in the Ninth Circuit were still territories. The exterior of that building still looks the same, as you all know, except that we don't have horse-drawn carriages out front anymore. The federal government wanted to send a message of stability and confidence when they built this building. It was a modern building, and they were very proud that it had electric lights and running water. And as you know, it has these incredible interiors. This photo shows the immigrant craftsmen from Italy who camped out and created this lovely space for all of us. I think their names have been lost to history, but they deserve credit for their remarkable work, and so I've included this slide. These workers created, among other things, this mosaic tile mosaic of Lady Justice, and she appears over and over again in our courthouses throughout the Ninth Circuit. I start here because for many decades, Lady Justice was just about the only woman in the Ninth Circuit. Women were not judges or lawyers when the Ninth Circuit courthouse was open in San Francisco, nor were they clerks of court. In fact, although the federal government was very proud of its modern courthouse, and justifiably so, it's beautiful, I like to remind people that this building was built without women's bathrooms, because at that time women couldn't even serve as jurors. It's hard for us to imagine now, but when we talk about the history of the suffrage movement, it's important to realize just how completely absent women were from public life 100 years ago in order to put the struggle to ratify the 19th Amendment into context. Each of the 9 Western states has its own suffrage history, and it was my pleasure to work with Robin and others on a few chapters in this journal edition devoted to telling the story out West. Most involve the liquor industry, because everywhere the suffrage battle was fought, the liquor industry opposed it. The idea was that if women had the right to vote, the liquor lobby was convinced they would exercise that right to outlaw alcohol. And the other strong arguments against suffrage, of course, had to do with the fact, and it's sort of depicted well in this cartoon, it's very typical of the kind of cartoons that were popular at the time, showing a woman dressed in fancy clothes, abandoning apparently her crying children to a husband who looks most annoyed by the development. Ratifications in the campaigns in the West involved a lot of dirty tricks and deception and numerous efforts, numerous tries to pass ratification before women were finally able to vote. When people think of suffragists, I know I thought of women from the East Coast wearing big hats, of Susan B. Anthony and Elizabeth Cady Stanton. And there's no question that both of those women were incredibly important to the campaign. But it's also important to recognize how many decades this took. Neither one of those women ever lived to see the 19th Amendment ratified. Neither of them ever voted lawfully. Susan B. Anthony voted once illegally as an act of civil disobedience. But really, they did not live to see the day. It was the Western states that first granted the right to vote to women. Wyoming territory was first, as Judge McKeown has explained, followed by Utah, then Colorado, and then Idaho, all before the turn of the century. Most historians credit the influence of the Mormon Church out west as establishing a foothold. The leaders of the church were already natural adversaries of the liquor industry and apparently not afraid to take on that powerful liquor lobby. The campaign in the Pacific Northwest proved to be a catalyst for a nationwide campaign. A suffrage from Portland, Oregon, by the name of Abigail Scott Duniway was critically important, even though she seemed to antagonize just about everybody she encountered. I've included this slide so you can see her advertising one of her talks, but also because several of you will probably have seen the Duniway Hotel in downtown Portland. It has a lot of cool memorabilia devoted to her and to her brother. They both ran their separate newspapers on opposite sides of the suffrage issue, by the way, in Portland. Duniway supported her family by printing her own newspaper devoted to the suffrage cause beginning in 1870. And she traveled extensively throughout Oregon and Idaho, in particular speaking. And she spoke wherever she could gather an audience of two to anybody who would listen. After reading many accounts of her life, I came away with the idea that she was tough and controlling and really not easy to get along with, but she was also a very effective agitator for change. In 1871, Duniway invited Susan B. Anthony to come all the way out to Oregon. The invitation alone was probably something of an outrageous bet because it was really tough to get from the East Coast all the way out to Oregon, much less traveling throughout Oregon and Washington at that time. But Anthony no doubt accepted because things were looking pretty rough. They'd only really achieved success in Wyoming and Utah at that time. To give you an idea of just how difficult the journey was, though, the distance between Seattle and Portland we now cover in about 3 hours by car. It took Susan B. Anthony a week to travel that distance because there were so many stumps still on the road, and her diary shows that slowed down the horses and she had to get out and walk much of the way. But Washington was encouraging. They had narrowly missed by one vote that an opportunity to include a suffrage amendment or a provision in their territorial convention. And then there was the fact that some women in Washington were actually voting as a result of a Civil War era bill that the legislature there passed. It was actually an intent to disenfranchise African American men. It provided that all white citizens over the age of 21 could vote, even though it was aimed at disenfranchising African American men. Some women in Washington who were over the age of 21 and were citizens and were Caucasian decided that it applied to them, and so they showed up to vote. And they were allowed to vote in some places. Still, Anthony definitely had her work cut out for her. Reporters in Washington usually mentioned the fact that she was unmarried right at the top of their articles when they were reporting on her speeches. Apropos of nothing, they reported that she was unmarried and then went on to describe her personal appearance before they ever got to the subject of what she had to say. And they usually described her personal appearance in pretty unflattering terms. It was brutal. One story I read described her as unmarried, tall, bony, and plain. So it was tough. Anthony's last stop in Washington was an address to the legislature there in Olympia. She was the first woman to speak to the legislature in Olympia, and the logic of her arguments won over the editorial staff of at least a couple of the newspapers. The Olympia transcript reported, quote, "Miss Anthony is a woman of more than ordinary ability, and the manner in which she handled her subject before the legislature was ample warning to members of that body who opposed suffrage to be silent." But her detractors were brutal and often hyperbolic. The Territorial Dispatch told its readers that Anthony was a revolutionist, aimed at nothing less than the overthrow of every social institution for the protection of the altar, the family circle, and the legitimacy of our offspring. And it went on and on. More reports like the latter than the former, I'm afraid. But the size of her audiences grew over the course of her tour, and she received increasingly favorable press coverage. In fact, perhaps because her final speech in Olympia was so well received, the legislature passed a bill removing any ambiguity about that Civil War era statute the day she left town. Rather than allowing all white citizens over the age of 21 to vote, they clarified that they meant all male white citizens over the age of 21. So ironically, the women in Washington, I should say, won and lost the vote 3 different times before it was all over. And ironically, the first time they lost the right to vote was probably because of this speech by Susan B. Anthony. Nevertheless, Abigail Duniway, the very flamboyant suffragist from Portland, who had invited Anthony out west, followed her around that 2-month period of time, and she learned a lot. And Duniway became an effective and forceful advocate in her own right. She wound up moving to Idaho for about 7 years, and she was there during the critical years, convincing the legislature to adopt the bill they passed in 1895. But then, of course, it had to be ratified. Susan B. Anthony was still head of the national organization, and she was aware, very aware of Duniway's personality, and she actually ordered Duniway out of Idaho for that ratification effort because she knew how cantankerous Duniway could be, and she sent in a woman by the name of Emma Smith DeVoe to lead the ratification effort. DeVoe was consistently described as quiet, ladylike, well-educated, and polite. She had a lovely singing voice and often started her talks by singing a little song or tune. She advocated an approach called the still hunt, where women were to avoid controversy, certainly to avoid the liquor controversy, and instead to just lobby their husbands, their brothers, their sons, their fathers, and so forth. It was definitely a slow grassroots campaign. But in Idaho, it worked. The very soft sell approach worked. In the end, only 3 of Idaho's 65 newspapers opposed the final amendment. It passed in 1896, and so Idaho was 4th. After success in Idaho, DeVoe moved to Montana, and she started all over again, organizing women's clubs and the very laborious grassroots effort. Within a year, she had organized about 35 clubs with between 300 and 400 members. But more defeats followed right in that time period. Oregon had a really disastrous defeat. Montana voters passed up the opportunity to adopt an amendment, and there was another defeat in Washington state. So it was in all, there was a 10-year period where the suffrage really stalled out. But the national organization realized that there was a glimmer of hope in Washington state, and the tide was beginning to turn. It was still, yes, it was just a state then. The tide was beginning to turn, and the organization sent Emma Smith DeVoe from Montana. This time they called upon her from Montana to move to Seattle to start organizing there. She set up shop in Seattle. At about the same time, a woman by the name of May Arkwright Hutton moved from Idaho to Spokane, and she set up shop there. It was important, they knew, to get a constitutional amendment. I should say that in the 1880s in Washington, the legislature had twice passed a couple of different measures granting women the right to vote, and both times the territorial legislature knocked those down and deemed them unconstitutional for various reasons. I put up, but I'm not going to take the time to go through this case law, but I've included a couple of the territorial citations to these cases in case you're interested in reading them. They do make for an interesting read. To give you an idea of how big a problem the Washington Territorial Supreme Court was, one member of the court actually resigned his seat on the court so that he could take up and personally argue a particular case that was coming up to his court and make sure that the suffragists were defeated. And so they adopted this final campaign that I mentioned. And with these 2 very unlikely women, DeVoe, as I've described, very soft sell approach in Seattle, and then Hutton, May Arkwright Hutton, who'd taken up residence from Idaho to Spokane. May Arkwright Hutton was a lot like Duniway and very unlike DeVoe. She was physically imposing. She was quite tall. She dressed outrageously, although you don't see that here in this photo. She reveled in controversy and really tackled everything head on. And that was her consistent approach to, it seems to be, to just about everything. She drove a red car, which I didn't even know existed at that time, but in 1906, she drove herself around Spokane in a red car wearing a black and white zebra skin coat, so you wouldn't have missed her. These two women were president and vice president of the campaign in Washington, such an important campaign, and they just about drove each other crazy because they were so different temperamentally and had really different ideas about how to approach this. To their credit, when they were still working together, they managed to get the legislators in Olympia to pass a provision to amend the Constitution, but of course, then they had to get that ratified, and that's when they went their separate ways. Hutton formed her separate organization in Spokane with the tactics, as you can imagine, what her tactics were, very, very forceful, and DeVoe stayed camped out in Seattle. The one thing they did agree upon while they were still working together was to publish a cookbook and as a fundraising tool. And lots of women's organizations did this to promote suffrage. The one in Seattle is this little rinky-dink one, frankly. And I had a copy of it on my desk for months before I bothered to open it up and flip through it because I wrongfully assumed it was just a cookbook. And what I found was that after about 200 pages of recipes and just before a chapter on helpful household hints, they had sandwiched in between some suffragist propaganda, including some pretty fiery essays that explained to women what was happening in the suffrage movement, in particular, the dirty tricks that the liquor industry had adopted in order to defeat a couple of their efforts. The suffragist idea was that women wouldn't mind being seen buying a cookbook, but they might not be so excited about buying a suffrage newspaper, and their husbands might not be so happy to see that kind of literature coming home. So they adopted this strategy, and that was, as I said, widely used. The Washington campaign broke the national logjam. It was incredibly important. It had been at that point a 14-year dry spell, but by the time they were successful, and as you can see in this map, then Washington became the fifth. The following year, after Washington was successful, California's campaign was successful in 1911. Arizona and Oregon both followed suit in 1912. Alaska in 1913, Nevada and Montana in 1914. So it must have been a really exciting time for the suffragists because it was just sort of dominoes then moving through the West. Of the states in the Ninth Circuit, only Hawaii was not included prior to the passage of the 19th Amendment in 1920. I'll take just a minute on the California campaign because the way I've described the Washington campaign with the two very different approaches was really typical in Washington, Oregon, Idaho, and Montana, really quite typical. And the trick was to figure out which method to adopt, when to be really a hard sell, and when to perhaps dial back those tactics. California was different for a couple of reasons. First, because it was a real squeaker of a campaign. They very, very narrowly ratified the amendment there by about 1.5%. The other thing that was different in California is that while women's clubs were successful in getting Sacramento to pass the amendment, they'd had trouble getting it ratified. And in the end, the reason it was ratified, I think historians widely agree on this, is that organized women, working class women, convinced the labor unions that if women had the vote, they would be natural allies of organized labor. And the men who were members of unions overwhelmingly voted in favor of the suffrage amendment there, and they're really credited with the final success. I want to take just a minute to tell you a little bit about my favorite suffragists out west, because I think a lot of them are women lawyers, and it's fun to hear about their stories. This first person is Adela Parker. And she was, believe it or not, a graduate of the second class ever graduated from the University of Washington's Law School. I had no idea they had graduates, but it turns out they had 3 back in 1903, which was pretty great. She worked as a high school civics teacher, but she made it her business to keep track of the liquor lobby, and she's the one who wrote those essays explaining to women what the liquor lobby was up to, including the ones that were slipped into the cookbook. Jeanette Rankin was a student at the University of Washington and part of Emma DeVoe's team in Seattle. It turned out that one of Emma DeVoe's contributions was that she really mentored a lot of very important suffragists, including Jeanette Rankin. After the Washington campaign was successful, Rankin returned to her home state of Montana and crisscrossed that state working on suffrage. She worked really hard and logged 9,000 miles campaigning for ratification. If her name sounds familiar, it's because she went on to become the first woman elected to the United States House of Representatives. Another veteran of the Washington campaign was Cornelia Templeton Hatcher. If you've come to Alaska and gone hiking in Hatcher Pass, I know Judge McKeown has, that's Cornelia's husband, who was the founder of Independence Mine out there, and Hatcher Pass is named for that family. Anyway, Cornelia, who had been also at the University of Washington, came north to Alaska after the campaign in Washington, and she's the one who successfully petitioned the Alaska Territorial Legislature to grant women the right to vote as the very first act of its inaugural session. The last individual suffragist I want to mention is Bird Wilson, and I have to include her both because she has a fabulous name and also because she started out as a secretary to a judge on the Ninth Circuit Court of Appeals by the name of Judge William Morrow. While Bird was working for Judge Morrow, she attended Hastings Law School, and at age 41, she returned to Nevada, and she was very instrumental there in the suffrage movement. She authored a pamphlet called Women Under Nevada Law to educate women about just how inferior their legal rights were. 20,000 copies of the pamphlet were published and distributed throughout Nevada. I want to close out my part of the presentation by telling you what I began with, which is that the story of the suffrage movement out west, while it's certainly something to celebrate, was not all roses. It's important to be clear that ratification of the 19th Amendment did not mean that all women were able to vote, any more than ratification of the Civil War era amendments meant that all African American men could vote. As I said, there were poll taxes and literacy tests and civility tests that sprung up in the wake of the 1920 vote. This cartoon appeared in my home state in Alaska, and it seems to compare up top. You see the legislature bowing very magnanimously and handing the vote to women without them. That was the myth, that women had never even asked for it. And then contrasting below, the cartoon shows the women in London being pelted with rocks and stones. No question, women in London had a much tougher time. But women in Alaska did petition for the right to vote here. And more importantly, more to the point, the truth is much more complicated than the story that some history books tell, which is that the inaugural session of the legislature, as its very first act, granted the right to vote to all women. In fact, what happened is that the Alaska legislature granted the right to vote to citizens over the age of 21, but there was no consensus that Alaska Natives were citizens. The argument was that because they'd been born in the territory before Alaska was a state, or perhaps even born while Alaska was still part of Russia, that they were not United States citizens. And so Alaska, this inaugural act that is often celebrated, unfortunately, the truth is that it actually disenfranchised Alaska Native men and women. In 1915, a bill was passed granting citizenship to Alaska Natives, but this citizenship came at an incredibly steep price. It required Alaska Natives to literally renounce their tribal affiliations, sever all tribal connections, and provide proof to a federal judge that they had adopted the habits of a civilized life. It was literally called a civilized life. That was usually judged by what people ate, what clothing they wore, and where they worshiped. Native Americans in the lower 48 who'd been born on reservations faced the very same discrimination and the allegation, the charge, that they were not US citizens. In 1924, Congress passed the Indian Citizenship Act that put the citizenship battle to bed, but other barriers sprang up, including most prominently literacy tests that prevented all sorts of different people from voting, African Americans, Mexican Americans, Chinese Americans, and so on. Prevented thousands of people from exercising their right to vote and persisted for years. I'm just about out of time, but I wanted to leave you with the thought that although I certainly celebrate the adoption, the ratification of the 19th Amendment, this chapter in our history is painful and it's complicated. And since I think it is so important that we learn from our history, I want to be sure to just give a shout out to everyone that the real story, which I think is very fascinating, is definitely a story of 2 steps forward and 1 step backward. And as I said, while I celebrate the amendment, I hope that you'll take time to learn the full story. I thank you so much for your attention and for the invitation to speak today. And now I'm turning this back over to Judge McKeown.
Thank you. And now we will move on to the East Coast and Seneca Falls. So there was this big convention, the Seneca Falls Convention, which we've all heard about. 300 people, men and women joined and came up with what was called the Declaration of Sentiments. And it was a whole host, a shopping list for women's rights. But the most controversial had to do with women getting the right to vote. And in the end, Elizabeth Cady Stanton and abolitionist leader Frederick Douglass gave moving speeches, and finally the convention agreed that too would be part of the Declaration of Sentiments. Now, during this time, the movement was primarily characterized by white women, but it was also true that during the convention and on other occasions, the women were liaising with other groups. For example, the Iroquois Confederacy, which was basically a matriarchal society, was enormously helpful in moving ahead the right to vote. As Judge Christen mentioned, the Women's Christian Temperance Union, of course, anti-alcohol, also was dancing with the suffragists. And there was some thought that if women got the right to vote, it would purify the government and also go after the liquor lobbies. So this was a delicate balance and dance of expediency going on. And of course, the suffragist movement was also linked with the abolitionist movement, which the professor will talk about. Now, following the war, Civil War, when we had the 14th and 15th Amendments, the suffragists took hope that maybe that would be extended to men because it talked about equality. But alas, that didn't happen. And it was said during that era that it was not the woman's hour. And that became the title of a wonderful book on the 19th Amendment, History by Elaine Weiss. So it was in 1872, the first time following ratification of the 14th and 15th Amendment, that there was an opportunity for suffragists to test equality. And so Susan B. Anthony, with a group of others, actually kind of got by the electors and went in and voted, which was illegal. And she was then arrested and brought to trial, ultimately, through a whole series of machinations, et cetera. And who sat on her trial? But Judge Ward Hunt, who actually was a Supreme Court justice, riding circuit, and sitting on the trial. He never even let the jury deliberate. Instead, he directed a verdict of guilty. And it was kind of like reverse jury nullification, only it was engineered by the judge. Eventually, she got to testify at her sentencing. He asked if she had anything to say, and she said, "Oh boy, do I have something to say." And she basically said, "You, the judge, trampled on every vital principle of government. My rights, my civil rights, my political rights, my judicial rights." So he ordered her to pay a $100 fine, and she responded, "I shall never pay $1 of your penalty." And she never did. We do know that later we had the Susan B. Anthony dollar. Her lawyer actually paid the fine, and you may have heard that recently she was granted a pardon. So then the suffragists, of course, realized that they couldn't win in court. So how about picketing? And so we next see them fast forward to picketing in front of the White House. And this was a march on Washington. 1913 was one of the original marches, and then they continued to march. And they were trying to put pressure on President Wilson, but he wasn't having any of it. So he basically evaded them for some years to come. The suffragists were very, very strategic in how they went about their message. And let me also turn to the cookbook theme, which Judge Christen mentioned. This was one of the best examples of how they did their advocacy. It was both strategic and political. So they had about a half dozen cookbooks. And in this particular cookbook, 1886, the editor said this was our messenger, and it would be both a blessing to housekeepers and an advocate for enfranchisement. So there was this strange double entendre of the women wanted to show we can be in the home and we can be outside the home. I had the privilege this year to serve as the chair of the ABA 19th Amendment Commission. So I had this idea, if the suffragists had a cookbook, we should have a cookbook. And here it is. So we put together the 19th Amendment Centennial Cookbook, 100 recipes for 100 years. And we have recipes from Supreme Court justices, international jurists, lawyers, judges, human rights, civil rights leaders from around the world. And you'll see at the bottom, the 19th Amendment Cookbook.com. You can go online and get this for free. And we decided this should not be something to make money, but something to celebrate. So if you want the recipe for Justice Ginsburg's ratatouille provided by her husband Marty from his cookbook, you can see it, or Justice Breyer's pot roast, or Justice Gorsuch's green chili recipe from Colorado, you can see that as well. So I encourage you to go online and to download the cookbook and to use it and cook your way through. Because in fact, during COVID, we know so many people are at home and we know they're cooking. And so we got a huge response to our request for this. Let me turn to one other subject that the suffragists face. There were two major issues that they could not have envisioned. Two catastrophic events, World War I and the pandemic of 1918. In fact, Kat, one of the suffragists herself, was stricken by the flu. World War I turned out to be a rallying cry because women replaced men in the labor force. And when the men came back, the women argued, if we're going to promote democracy abroad, shouldn't we have the vote at home? They had taken on manufacturing jobs, labored in the farm fields, and of course gone on the front lines in nursing positions. So with women as the glue that held the country together, there was a lot of pressure on President Wilson, and he faced a very contentious midterm election. So he finally voiced his support for the amendment. And he said, shall we admit them only to a partnership of suffering and sacrifice, and not to a partnership of privilege and right? So that was a major push in the right for women's votes. But at the same time, women were facing the 1918 influenza pandemic. So all of a sudden, all these marches and all these efforts to bring women into the streets and men into the streets totally came to a halt. Marches, rallies, parades, and soapbox speeches. So the suffrage movement was not canceled, but it looked very, very different. And in many ways, it paralleled what we see today with COVID. It's changed the way, just like this virtual presentation and other platforms, of how we connect with family and friends and communities, how we hold court hearings, and how we continue business. And in the same way, the suffragists shifted their tactics. And interestingly, there was another parallel to today. They turned to the US mail, and they also turned to phone calls, posters, banners, and news advertisements. And they also turned to cartoonists, and some of those cute cartoons you'd seen from Judge Christen. So as we were leading up to ratification, Congress finally passed the 19th Amendment, but of course it needed 36 states to ratify it. And the ratification in the end came down to one state, because the suffragists realized there was only one state that they could really realistically win, and that was Tennessee. So it turned out Florida and North Carolina waited another 50 years to approve ratification. So with this strategy narrowing, everybody descended on Tennessee. And it was interesting because the anti-suffrage movement used all kinds of broadsides to attack the women. And they said, do not listen to the song of the suffrage siren. Seal your ears against their vocal wiles. A major player in Tennessee on behalf of the National Woman Suffrage Association was Carrie Catt. So she took a long train ride from New York and she installed herself at the Hotel Hermitage. That was her headquarters, but it was also the headquarters of the Antis, as they were called. And the Antis actually ran what they called the Jack Daniels Suite. So liquor plays a big role in the suffrage movement. The Antis figured if they could get some of these legislators drunk, then maybe they wouldn't be there to vote on the final amendment and whether Tennessee would ratify. And in the spirit of the day, many politicians were accepting bribes. So it was really backroom politics at its best or worst, depending on your perspective. So until the vote actually happened, Hotel Hermitage with Catt, the Jack Daniels Suite, and a lot of politicking going on was basically strategy central. So they quickly passed the Senate, and then they were left with the House of Representatives. And the Speaker of the House tried to table the amendment. And sometimes the legislators even went out of town hoping they could not have a quorum. Finally, it came down to the youngest member of the legislature, Harry T. Byrne. He showed up in the chamber with a red rose on his lapel, and that meant he was against the amendment. But he also had in his jacket pocket a letter from his mother. And here's what she wrote. Hurrah and vote for suffrage. Don't keep them in doubt. I noticed some of the speeches against. They are bitter. I have been watching to see how you stood, but I haven't noticed anything yet. So she said, please help Mrs. Catt put the rat in ratification. So the mood was pretty hostile, but in the end, it was the aye or yes vote of a 27-year-old man that helped enfranchise 140 American women. And it was the largest democratizing event in US history. So here we have then the banner of a woman has registered to vote. And I'll leave you with this message that sometimes it pays to listen to your mother, as Mr. Burns did. Now with that, I want to turn over to the professor, and I just show you these images of Sojourner Truth, who is both an abolitionist, a women's rights activist, and an author. And I have the pleasure every week to walk by this statue of her at the University of California, San Diego. And that is the story of how the women finally, along with a lot of very, very good men, pushed the 19th Amendment across the line.
Good afternoon, and thank you very much to the Eastern District of California and to the 9th Judicial Circuit Historical Society for inviting me to be part of this conversation. In 1920, the open secret of the 19th Amendment's ratification was that nothing in it would prevent the individual states from continuing to disenfranchise African American women. Whether it was members of Congress who promulgated the 19th Amendment, state lawmakers who ratified it, or suffragists themselves, everyone understood that nothing in its terms prohibited the states from strategically using poll taxes, literacy tests, understanding tests, and more, as we've heard, to keep Black women from registering to vote. Nothing in the new amendment promised to curb the intimidation and violence that threatened Black women who came out to polling places, voting rights and voter suppression went hand in hand in 1920. And there are, I think, two myths that continue to swirl around the 19th Amendment even today. The first is that the 19th Amendment gave American women the right to vote. You might often also even hear that it guaranteed to American women the right to vote. And on the other hand, a second myth, one that in a sense runs contrary to the first, is one that goes something like, no Black American women gained the right to vote in 1920, that racism continued to keep Black women from the polls. Now in this group, I don't think I need to rehearse the terms of the 19th Amendment itself. You all know the Constitution as well as any audience I've spoken to. But there is the question of what then did it mean for American women that no longer could sex be a criteria when the individual states meted out voting rights. Now laws that reserved the ballot for men clearly violated the Constitution, and still the 19th Amendment did not promise any American woman the right to vote. Laws, state laws, still kept women from the polls based upon age, citizenship, residency, mental competence. In 1920, it was still the case that American women who married non-citizens were denaturalized and hence ineligible to vote. Women showed up to register in the fall of 1920, and still they confronted many hurdles, even if sex was not one of them. And of course, one additional barrier to women's votes persisted even after a federal amendment, and that was racism. It was true that the 15th Amendment in 1870 had expressly forbid states from denying the vote because of race, but by 1920, lawmakers in the South and the West, as we've heard, had set in place hurdles that, while silent on their face about race, had the net effect of disenfranchising Black Americans. Poll taxes, literacy tests, grandfather clauses had effectively kept many Black men from casting ballots since the 1890s. Unchecked intimidation, the threat of lynching sealed the deal. Local voting officials effectively constructed a color line without ever having to invoke race. So did American women win the right to vote in 1920? Not all women. African American women in too many states became mere equals to their fathers and husbands. State laws disenfranchised them in an end run around the spirits of the 15th and 19th Amendments, and the registration numbers reflect the effect of these discriminatory laws. In the fall of 1920, Black women presented themselves to voting officials, but many found the books were closed. And still, even before 1920, the first waves of Black women voters had been unleashed as individual states made women's suffrage the law. Significantly in California starting in 1911, Illinois in 1913, and New York in 1917, Black women were already experienced voters by 1920. Even more managed to register and cast ballots in the fall of 1920 in the wake of the 19th Amendment. How did they accomplish that? One example comes from St. Louis, Missouri, where African American women organized under the auspices of the Phyllis Wheatley branch of the YWCA, named for the 18th century enslaved poet. There, Black women ran a suffrage school that prepared them for their chance to register. They taught one another how to pay poll taxes, how to pass literacy tests and understanding tests when they were administered, even by begrudging officials. And if newspaper reports are correct, women turned out, and papers reported that nearly every woman in the city of St. Louis registered in that season, Black and white. For Black women in St. Louis, however, getting to the polls was no mere exercise in fulfilling the promise of the 19th Amendment. No, nor was it the actualization of their aspirations to citizenship. What Black women in St. Louis knew was that local officials were using Election Day, using popular referenda to set in place a increasingly robust Jim Crow regime, specifically housing segregation ordinances that had been on the ballot as recently as 1916. In that year, Black men had been intimidated and discouraged from the polls, even being arrested on election day at polling places when they showed up. In St. Louis, Missouri, when Black women show up to register and then to vote, they do so in the interests of their rights as women and, of course, in the interests of civil rights. Our other example comes from the city of Daytona in Florida, and there, educator and National Association of Colored Women's Clubs leader Mary McLeod Bethune was traveling the state in 1920 to encourage Black women to register, only to be confronted by brutal opposition each step along the way. Mrs. Bethune confronted bombing, she confronted assault, she confronted a wave of violence instigated by the Ku Klux Klan that overtook the state of Florida. On Election Day Eve in 1920, white-robed Ku Klux Klansmen marched first into downtown Daytona and then continued on horseback to the grounds of Mrs. Bethune's then school, industrial school for African American girls, today the campus of Bethune-Cookman University. Klansmen walked onto that campus to intimidate Mrs. Bethune, to intimidate her faculty, and more broadly to intimidate the Black women of Daytona. They were not successful in 1920. And the next day, Black women turned out in numbers together in another strategy that they hoped would stave off the intimidation and violence that they faced. There was a kind of safety in numbers in Daytona in 1920, but it was short-lived. And by 1922, the violence and intimidation continued. Again, Mrs. Bethune's school was visited by the Ku Klux Klan on election eve, and she will, despite being one of the state's most committed voting rights advocates, will abandon the efforts to get Black Americans to the polls in the state of Florida. Violence and intimidation continued unchecked and rode over whatever constitutional provisions might have been afforded them by the 15th and 19th Amendments. So it's 1920, and African American women, when they look out across the national landscape, recognize what an uneven patchwork of voting rights they are confronting. What to do? Well, under the auspices of the National Association of Colored Women, its president, Hallie Quinn Brown, who represents some 300,000 African American women organized across the United States, Hallie Quinn Brown sets the organization's sights now on winning federal legislation that would give teeth to the 15th and 19th Amendments, legislation that would override and undo the state laws that continue to keep Black Americans from the polls. How to get there? Well, in order to get there, Hallie Quinn Brown understands that African American women must lead now in a new movement for voting rights, one that will, in essence, be built out of the ashes of the 19th Amendment. And she sets her sights on building alliances, including those with the women like Carrie Chapman Catt and Alice Paul, who had led those organizations at the fore of securing ratification of the 19th Amendment. Hallie Quinn Brown will, in the winter of 1921, call on Alice Paul to implore her to join with African American women to continue in the struggle for voting rights for women, and now extend both her political influence and her political savvy to the project of winning federal legislation that would protect Black voting rights. And she calls on Alice Paul that winter. The words that they exchanged have not survived, but what we know is that in the wake of that visit, Alice Paul will begin to fold up the National Women's Party, will decline to join with African American women. Alice Paul will move on, and by 1923, she will begin a movement for yet another federal amendment, this time the Equal Rights Amendment, leaving African American women behind and alone to continue the struggle for women's voting rights. That is the movement that takes us to the hallmark moment for African American women in the story, which is 1965 and the passage of the Voting Rights Act in that year. It is a story that moves along 3 tracks over the course of 45 years. The first is a track that continues the efforts that Black women had long been making in the trenches of voting rights each and every election cycle. The ground game of American politics continues to be part of Black women's strategy for exercising political authority. No place better was that exemplified than in the city of Chicago, where African American women had been voting since 1913 and where they will become important operatives in the Republican Party, and they will use their power at the polls collectively. They will vote as a bloc to transform not only the face of the city council in Chicago, but also begin to transform the face of the federal Congress. In 1928, Black women in Chicago will be largely responsible for sending Oscar DePriest to Congress, to the House of Representatives in that year, the first African-American man to be elected to Congress since 1901. This, the ground game of politics in every election cycle, is part of Black women's strategy for increasing their access to the ballot and the influence of those votes. Secondly, there is a legal campaign waged by the NAACP. Here, both litigation and lobbying leads to important compromises to the edifice of Jim Crow. The NAACP is able to challenge poll taxes, is able to challenge grandfather clauses, is able to challenge successfully whites-only primaries, chipping away at the edifice of Jim Crow along the way to then lobbying for what will be the Voting Rights Act of 1965. And finally, African American women are on the ground by the 1940s, building what we remember as the modern civil rights movement. Women like Septima Clark, Fannie Lou Hamer, Diane Nash, Ella Baker, and more are, if you will, the best remembered among the hundreds and thousands and tens of thousands of Black Americans, including Black women, who put their bodies, their reputations, their vocations, and more on the front lines across the American South in a campaign that, again, forces the hand of Congress, forces the hand of President Lyndon Johnson, and wins for Black Americans in 1965, the Voting Rights Act. We sit in 2020, and there is, I think, sometimes a temptation to take the view that nothing has changed, or perhaps too little has changed since 1920. And certainly, to the degree that we observe voter suppression and the pragmatic questions of how Americans get to the ballots persist even into the 21st century, it is true that the story of the 19th Amendment is hardly myth. It is really a cautionary tale for our own time. And at the same time, a great deal has changed. And African American women, the force that Black women have become in American politics today in the 21st century, I think it's fair to say that African American women, like those whom we recognize today as part of the fabric of our political life, were nearly unthinkable in 1920 when Black women faced brutal opposition to the simple exercise of voting rights. A few examples. We know today, as they did in 1920, African American women continue to vote as a bloc. That is evident, for example, in the case of the state of Alabama in 1917, when during that special election, African American women organized vote turned out in through those very same networks that they had used in 1920 to get to the polls. Those networks are activated in 2017. Black women's votes put the Democrat Doug Jones over the top and flip that seat from red to blue in a Senate in which, as we well know, every vote matters. Perhaps many of you, like me, have already cast ballots. And when we collectively bring our ballots together, part of what we might recognize is that in this year, somewhere between 120 and 130 African-American women are running for seats in the US Congress in 2020. This is a record-shattering number of Black women running for office. The high bar had been set 4 years ago in 2016 when 48 Black women had run for office. This is no longer an era of African-American women's firsts. This is now an era in which African-American women are indeed moving to be a force in American politics. And if you had missed those 120 or so women, it's unlikely that you've missed California Senator Kamala Harris, who is running in these weeks for the vice presidency. And perhaps like me, you had an opportunity to watch her acceptance speech when she was nominated back in August of 2020, because among much that was said on that evening, Senator Harris offered us a history lesson about the political tradition out of which she has come, out of which she has emerged. It is not a political tradition that rests upon the lives and the work of women like Elizabeth Cady Stanton and Susan Anthony, nor does it rest upon the work of Carrie Chapman Catt or Alice Paul. Instead, Kamala Harris offered up her own version of the pantheon of women's rights and the pantheon of African-American women's voting rights and political power. And it included these 6 women: Mary Church Terrell, the first president of the National Association of Colored Women, one of the early 20th century's most staunch suffragists, who, while she made her political home among African-American women, was someone who always insisted that Black women should have a seat at the table, the national table, run by white women, as politics took them along the road to the 19th Amendment. Kamala Harris invoked Ida B. Wells, the journalist, great anti-lynching advocate, and a suffragist who laid the foundation for Black women's voting advocacy and their political influence in the city of Chicago as a founder of that city's Alpha Suffrage Club. She invoked Mary McLeod Bethune, who we've already learned was a courageous suffragist in the 1920s in Florida. Bethune would go on in the 1930s to help Franklin Roosevelt found his Black cabinet, an unrun by Black Americans around the problem of disenfranchisement. Mrs. Bethune understood that there was more than one way to exercise political power, even in the face of violence, even in the face of Jim Crow laws. And she becomes expert in the 30s and 40s at wielding the power of patronage to bring many Black Americans to Washington and into powerful decision-making roles in the federal administration. Kamala Harris invoked Diane Nash and Fannie Lou Hamer, 2 of the great heroines, sheroes of the modern civil rights era. Diane Nash, behind the scenes, the architect of the student sit-in movement in Nashville, Tennessee, of the freedom rides to desegregate transportation, and then finally the architect of the Selma campaign, the woman who worked behind the scenes to organize others to cross the Edmund Pettus Bridge in that decisive confrontation that does indeed force the hand of Congress on the question of the Voting Rights Act. Fannie Lou Hamer, who worked as effectively behind the scenes as she did in front of the cameras, a student nonviolent coordinating committee organizer, a former sharecropper, who leads in 1964 the Mississippi Freedom Democratic Party to the Democratic Party's summer convention. Mrs. Hamer will command the national television cameras to decry the Democratic Party's complicity with white supremacy, decry the seating of a Mississippi delegation to that convention that was chosen without the input, without the consultation, without the votes of Black Mississippians. She will shame Lyndon Johnson on the eve of that convention's nomination of the president for re-election. She will hold the feet of that party to the fires of the civil rights movement, again, forcing the hand of Johnson in Congress in the following year. Finally, Kamala Harris invoked the great Constance Baker Motley. Now that might be all too evident. The two, like many of us, share a vocation and membership in a guild. But of course, Constance Baker Motley had been a member of that NAACP litigation team that had chipped away at Jim Crow, including barriers to voting rights in the years before 1965. Judge Motley would go on to be a public servant, elected to office in the city of New York and then in the New York State legislature before finally being appointed to the federal bench. From these women, I have taken 3 lessons, and I want to share them with you. The first is that whatever the outcome of any given election cycle, including that one that we are facing in just 2 weeks, whatever the outcome in an election cycle, African-American women have for 100 years, despite formal disfranchisement, always played the ground game of American politics. It's about getting registered, possessing that ballot, casting that ballot, and having it counted. And Black women will continue to be committed to those principles going forward. At the same time, Black women were never only about the ground game in American politics. They were also about holding us up to some of our highest ideals. For much of American history, Black women were alone in insisting that neither race nor sex had any place in American politics, in arbitrating access to the ballot, access to office holding, access to political power. For most of our history, that was a lonely and oftentimes discouraging value to hold up. And yet, I think we can be sure going forward that Black women will continue to valorize some of our highest ideals. And finally, Black women are those who have been in politics for a long game. Many of the women about whom I write, many of those invoked by Kamala Harris, like Mary Church Terrell, Ida B. Wells, and Mary McLeod Bethune, did not leave lives long enough to see the passage of the Voting Rights Act in 1965, but they understood that the work of voting rights was the long game of laying the foundation, planting the seeds, and preparing daughters and granddaughters to do the work, the ongoing work of advocating for, protecting, and breathing life into our democracy. And so with that, I think I'll stop and say thank you very much. I think we're going to be rejoined by a moderator who will help us with questions and discussion. And thank you again for the opportunity.
Thank you, Professor Jones. And yes, we do have some questions. The first one I would like to present to all of our speakers, and it's asked, are there lessons from any women's voting rights movements applicable to the ERA, whether or not it becomes part of the Constitution?
Well, I'll take a stab at it. Well, first of all, I would say that there's so many differences between when the 19th Amendment and now a potentially renewed Equal Rights Amendment. I think Nevada actually was the first state to ratify the amendment after the expiration of both deadlines. But the interesting thing in the 19th Amendment is it was ratified by the states, 36 states, within a year of passing Congress. In the Equal Rights Amendment, it had 7 years as a deadline and didn't meet that, so got an extension. So it ended up being 10 years, and you still had only 35 of 38 states ratifying. So I think that the lessons you have to learn from the suffragists were patience, flamboyance, and persistence. And it's a very different both political and legal landscape today. It'll be a ground game, just like the one that Professor Jones refers to. But first, there will be legal hurdles to see whether the withdrawal of ratification is effective and whether even any of the prior ratifications were effective. Not long before her death, Justice Ginsburg said she felt that the whole process would have to start from scratch. So there'd need to be a new amendment passed in Congress and then start over with ratification. So I think there's a lot of legal barriers to Equal Rights Amendment passage. But I also think that the truth is that while the 19th Amendment paved the way for voting and has done something over time in how we think about and frame gender equality, we still don't have a country in which women, regardless of color, national origin, or otherwise, have equality.
If I could jump in, I think I would just add that what we learned from the 19th Amendment is that all the amendment did is text, and that it will take, as it did 100 years ago, women's insistence on the meaning and the full meaning of the 19th Amendment to have it become an arbiter and a force in American law and politics. The Equal Rights Amendment, even if ratified quickly, will still require us to breathe life into it and to determine its full course.
I agree with the comments by both speakers and would just add that for me, the predictions about the Equal Rights Amendment and what it will mean, it just seems so reminiscent to all kinds of predictions about what would or would not happen if women gain the right to vote. So for me, it's sort of a deja vu moment. There's a passage that I really like from Stella Parker, the woman I mentioned, who was one of the activists in the Seattle campaign. She went on to serve in the legislature for a number of years at Washington State. And she was asked this question about women's issues and whether there was a women voting bloc and what would happen. And after serving in the legislature for many years, she said, "I've been looking for years to find any law that does not affect women. From a tariff on gloves to a declaration of war, the great problems which face the human race demand the genius of both women and men to solve. The law needs women as much as women need the law." So, so for me, the part that I would add to what the other speakers had to say is this notion of the dire predictions one way or another strike me as entirely premature and maybe a little silly.
Thank you. Now, Judge Christen, the next question I believe is for you because you did address the suffragist movement through California. And the question is it a fair assessment that much of the critical support came from the rural areas of California, now part of the Eastern District, through which supporters drove their blue convertible in a true grassroots campaign, and that the shift from counting on urban to rural support made the difference?
I don't know anything about blue convertibles, but there were a couple of differences about the California campaign. One being what I mentioned about the organized labor having playing such an important role. A way that the California campaign's ultimate success was the same as the other areas in the state, in the West, I should say, is that the rural counties in California were very important. That part is absolutely right. The Eastern District came through for sure. That was true. I noticed in Washington, for example, there was a demographic survey done there of the legislature that actually ultimately voted in favor of suffrage. And they were broken down, I started to say by race and gender, but of course they're all white men, so there wasn't much breakdown there. But they're broken down by, by their faith and by their profession and where they were geographically located and whatnot. And there was no common denominator except farmers. Farmers overwhelmingly supported suffrage for women. I have not seen anything scholarly written about that, but it strikes me as perhaps not surprising that farmers who had wives and daughters working right alongside them, doing very heavy manual labor at that time, were among the first to support suffrage for women. And that was certainly true in the counties that comprise the Eastern District, yes.
Excellent, thank you. Now the next question I have is for Professor Jones. And the question asks, can you speak to the career of Shirley Chisholm? And does Representative Chisholm's presidential campaign fit within the narrative you've described, or was it an outlier to this movement?
Thank you for the question, and the answer is it certainly does fit. Shirley Chisholm opens the final chapter in my new book, Vanguard, importantly because on the one hand, Chisholm's personal story helps us to appreciate the ways in which Black women's political education is the product of many generations of activism, political philosophy, and more. Chisholm credits her own father, for example, with her earliest political education. He was a member of Marcus Garvey's United Negro Improvement Association, an organization through which many Black American women develop their political acumen, exercise their political authority, even as they are kept from the polls and from office holding in many places. So she is part of a long political tradition among Black Americans. And wonderfully, Chisholm explains that when she was a student at Brooklyn College, she was a founder of the Phyllis Wheatley Society, the Harriet Tubman Society. So here, creating herself a political organization in part is an homage to the 19th and early 20th century of Tubman, who was herself a suffragist at the end of her life in upstate New York. Most importantly, of course, is Chisholm's own political career, because she is one of those figures who goes to not only testing, but really making manifest what the promise of the Voting Rights Act of 1965. And so we know she's the first Black woman to be seated in the US House in 1968, and by 1972 she will run for president. And this is a proving ground for what it is that the 1965 Voting Rights Act might mean for Black Americans beyond the local level, beyond the state level, and at the national level. That is a story that's still being written, but Shirley Chisholm not only sets out to write a chapter in that story, she is responsible in that campaign for igniting the future political careers of African American women going forward, most notably perhaps California's own Representative Barbara Lee, who begins her political career as a volunteer on Chisholm's 1972 campaign. So thank you very much for the chance to remember Shirley Chisholm and to underscore the important role that she plays.
Perfect, thank you, Professor Jones, appreciate it. And also I would like to take this moment to thank all of our speakers, Ninth Circuit Judges Margaret McKeown and Morgan Christen. And again, thank you, Professor Martha Jones, for your thought-provoking and enlightening discussion on the enfranchisement and disenfranchisement over the past centuries. And I would also like to thank again Robin Lipsky of the Ninth Judicial Circuit Historical Society for their assistance in putting together this presentation. Just so everyone knows, I have put links to Professor Jones's books in the chat section, and also a link to the cookbook that was referenced by Honorable Judge McKeown, in case you're interested in checking those out. Also, I am putting a link to the Ninth Judicial Circuit Historical Society in case you're interested in learning more about them. Thank you again, everyone. This will go ahead and conclude the Enfranchisement, Disenfranchisement, Then and Now session.